So you're standing on the sidewalk outside a bar in Pittsburgh South Side. It's late. Maybe there was some type of disturbance inside, maybe not. An officer walks up, asks you a couple questions, and then says something that catches you off guard. When cops ask to search your phone, most people freeze. What you say next determines everything. Can I take a quick look at your phone real quick? And right there, what you say when the cops ask to search your phone decides whether your texts, your photos, your search history, and every private conversation you've ever had stays yours or becomes evidence against you. Because here's what courts have already decided. Your phone has more legal protection than your car, your bag, or even your pockets. But later in this video, I'm going to show you the one situation where that protection disappears completely. And it's a mistake I see people make more than any other mistake. Now, your phone is different. In 2014, the United States Supreme Court decided a case called Riley versus California, and it changed everything about how police interact with cell phones. The court said this: police cannot search a cell phone without a warrant, period, even during a lawful arrest. That's it. Case closed. Think about what that means, though. They can arrest you, handcuff you, put you in the back of a squad car, and they still cannot open up your phone without going to a judge first. The court's reasoning was straightforward. A modern smartphone contains more personal information than you can fit into an entire house. Emails, photos, medical records, financial data, location history, going back months or years, text messages with your attorney, your doctor, your family. The court compared searching a phone without a warrant to finding a key in a suspect's pocket and arguing it allowed officers to unlock and search his house. That's federal law. It applies everywhere in America, including right here in Pennsylvania. The exact words to say when an officer asks to see your phone, here's the script: I don't consent to a search of my phone. You're welcome to get a warrant. That's it. 2 sentences. Let me explain how that works. I don't consent to a search of my phone eliminates any argument about consent. You've drawn the line clearly, and it's on the record. You're welcome to get a warrant. It's not hostile. It's not rude. It's actually directing them to follow the exact process the Supreme Court requires. You're telling them to do it the right way. If they push back, if they say it'll go easier for you if you just cooperate, or we're just going to get a warrant anyway, so you might as well, you have one follow-up line. I understand. I still don't consent. I like to speak to an attorney. And then stop talking. Shut it off. Don't explain why. Don't justify it. Don't apologize. Now, do you have to unlock your phone? This is where it gets complicated and where Pennsylvania law gets specific. Now, there's an active legal debate across country about whether police can compel you to provide a passcode or use your fingerprint to unlock your phone. Here's where Pennsylvania stands right now. In 2019, the Pennsylvania Supreme Court ruled that forcing someone to provide a passcode can violate the Fifth Amendment privilege against self-incrimination. The reasoning was that providing a passcode requires you to use the contents of your mind, which is testimonial. However, biometrics are treated differently in many courts. Fingerprint, face scan, those are considered physical characteristics, not testimony. Now, some courts have allowed compelled biometric unlocks where they would not allow compelled passcodes. My practical advice: if you're concerned about this, switch your phone to a PIN or a passcode before any encounter with law enforcement. A passcode has stronger legal protection than your fingerprint or your face right now. And regardless of how your phone is locked, the answer is the same. I don't consent. I want to speak with an attorney. Now, what about exigent circumstances? Officers have one major exception to the warrant requirement, and it's called exigent circumstances. That means a genuine emergency where waiting for a warrant could result in harm or destruction of evidence. If they believe that the phone contains information about imminent threat to life, they may argue that they had to search it immediately. But here's the reality. Exigent circumstances are rare, and they are heavily scrutinized by courts. An officer saying, "I thought he might delete something," is generally not enough. The emergency has to be real, and that emergency has to be immediate. I had a client. Let's call him Hassani. Hassani got stopped during a traffic stop out in Penn Hills. The officer told Hassani he needed to check his phone because the officer believed there might be evidence of drug activity. No warrant. No emergency, just a hunch. Hassani handed over his phone, and inside were text messages the prosecution used as the centerpiece of their case. Now, if Hassani had just said, "I don't consent to a search of my phone," the officer would have needed a warrant. And getting a warrant requires probable cause, which is a much higher bar than I had a feeling. That's the difference between evidence that sticks and evidence that gets thrown out. Now, what if they take your phone? Now, officers can seize your phone and hold it while they apply for a warrant. That is legal. Taking the phone and searching the phone are two different things. If they take your phone, don't fight it physically. Say this: "I understand you're taking my phone. I do not consent to any search of its contents." Then call your attorney. The moment they take the device, start noting the time and the circumstances. Time matters right here. Because in Pennsylvania, officers have to get that warrant promptly. They can't hold your phone for weeks while they figure out what to do. If there are unreasonable delays, your attorney can challenge the search. Now, here's the consent trap. If you watch my video on rights as a passenger during a traffic stop, you already know how consent works against you. The same principle applies here, maybe even more. Officers are trained to make the request that sounds casual. Just let me take a quick peek. Pull up your recent calls for me. Show me who you were texting. Every single one of these requests are for consent. And the moment you hand over your phone or pull up an app, you've opened the door. It doesn't matter that you thought you were just being helpful. It doesn't matter that you had nothing to hide. Once you consent, that evidence is admissible. Let's call her Maria. Maria was a passenger in a car that got stopped on the way back from Pittsburgh. The officer asked if she can just check her phone because he thought the driver may be involved in something. Now, Maria unlocked her phone and handed it over. There was nothing incriminating about the driver on that phone, but there were photos the officer decided were relevant in an entirely different investigation. Maria ended up charged. 6 words that would have prevented all of this: I don't consent to any searches. The principle is simple. Being helpful and being smart are 2 different things in law enforcement encounters. Helpfulness can become self-incrimination faster than most people realize. So let's do a quick recap. Your phone is constitutionally protected. Police need a warrant to search it, even after an arrest. You never have to unlock it. You never have to consent. Say it clearly. I don't consent to a search of my phone. You're welcome to get a warrant, then stop talking. Now, this video and the last video dealt with specific encounters, traffic stops, and phone searches. But what if the law itself is the problem? What if something that's completely legal can still get you arrested? It happens more than you think in Pennsylvania, and that's what I break down next. If you need to talk to someone about your situation right now, our contact information is in the description below.